All right, as we move into the judicial branch, I think maybe what might be appropriate here is just let's look at Lady Justice. Lady Justice is the symbol of the judicial branch, and hopefully none of you have, but if you've ever been in court, you've probably seen images of her. Now, she has a couple of key features that we need to kind of keep in mind here. First of all, the fact that she's a female. Secondly, that she carries a sword. Third, that she's wearing a blindfold. And fourth, that she has some scales. So, what I'd like for you to do is you can hit pause or whatever, but just think about real quick what you think this symbolism means. And I'll just take 5 seconds to give you an opportunity to hit pause, but I'll start in five. All right. So, does anybody have a guess? Why female? When I present this in class, often what students will guess is females tend to be judgmental, females tend to be the one who bring the justice in the household. Yeah, those are kind of right, but actually, she's female because she is modeled on the goddess Themis, who is the goddess of justice. So it's actually a really easy and you can kind of see that it kind of has that sort of Greek Roman look with the toga. Usually she's not wearing a shirt. She's kind of bare breasted as the toga slips over her shoulder. But this is a G-rated class, so we want to make sure that nobody's offended. But how about the sword? What do you think the sword represents? Often people will say, oh, well, that is the swiftness of the justice, or that is the punishment. And in some regards, that is correct. Notice it's not like a big old hammer like what Thor carries, or it is a double-sided sword able to bring swift and final justice. The blindfold represents, and maybe you've seen this before or read about it, that justice is blind. Um, that's kind of a more of a goal than it is the reality, because the reality is we know that justice is not always blind. If you did your reading before this, you saw that there was a boxer named Reuben Carter who was convicted of murder and served 20 years and ultimately found out to be innocent of those crimes. So justice is not always blind, but it's the intent is that it is blind, that justice is not swayed by one's gender or race or any of those factors. And then lastly, we get scales. Um, and scales is a way to measure something. So essentially, you're measuring innocence or guilt. So hopefully that gives you a little bit better idea. Now, um, oops, didn't make this big enough. Sorry, thought I should have, but anyway. Now, in the United States, I think it's probably easier to actually go to this one first. Actually, let's go to this one. So, in the United States, we have a system of courts, and if you watch the video at all, excuse me, you'll see that there are state courts, there are federal district courts, and in the United States, we have a lot of courts that were actually designated by the Constitution. Those include the federal district courts, the courts of appeal, the courts of international trade. I don't need to go in from all these. But as you see, Article 3 of the Constitution calls for the creation of the Supreme Court and such inferior courts as Congress may from time to time ordain and establish. So Congress actually creates a lot of these courts. How does a case make it to the Supreme Court? Well, essentially, first you have to file a case, usually in district court, although it doesn't have to. And as if you watch the video, you'll see from Crash Course, you'll see that probably the number one way that cases are filed are through state courts. The decision then usually the loser appeals that case, so it will then be sent to the federal appeals court, and then the loser of that case generally will appeal to the Supreme Court. So, it's a step by step. Very few cases actually make it to the Supreme Court without traveling this road. All right, so if we were to look at this kind of maybe gives you a little bit better understanding of. So on this side, we have at the federal level, at the national level. So there's 94 courts within the United States. And at this level, as the video explains, it usually has to fulfill some level of it has to satisfy certain requirements, let's say, to be accepted at the federal level. Most of them are first tried at the local trial courts, and that's usually what that means is at the state courts. Local, the most, or the courts that are at the bottom are more like small claims and family court and traffic court and things like that. But these courts are at the state court level. If you lose that, you can move on to the state appeals court. Then you can go to the Indiana State Supreme Court, and then you can actually appeal to the U.S. Supreme Court. So there's actually more of a chance to make it through this avenue than it is through this avenue, although not always the same. And then you have these courts outside of these two courts' jurisdiction, and they immediately appeal to the Supreme Court. A couple of constitutional principles that we need to just review here real quick, and they include judicial review, federalism, and checks and balances. First of all, judicial review is the power of the courts to determine constitutionality of the acts of government, makes the Supreme Court the final authority on the meaning of the Constitution. So within these early principles that were created when the Constitution was made, sorry, my allergies are hitting me. Judicial review was actually one that wasn't really set in stone, and the Supreme Court and the judicial branch really had to kind of carve that out. But the power of judicial review is one where the courts get to determine the constitutionality, meaning is it constitutional or is it not constitutional? Whether the acts of government or a law or something does not fit of the Constitution. And so that's kind of important. The other thing is you see its final authority. There is no place to appeal above the Supreme Court. So most recently we've had same-sex marriage made legal in the United States by the Supreme Court, and that's the final authority. So that is going to be law. Now, can states begin to challenge that? Certainly, they can find ways to, legal ways to begin to try to work around it, but then more than likely that will be brought up in front of the Supreme Court, and they will have to make a decision on it as well. We have federalism, the idea that there are multiple levels of government, or in this case, the judicial branch. So we have the local level of courts, we have the state level of courts, and then we have the national level of courts. So federalism itself really presents itself here. And lastly, we get this idea of checks and balances, and that's kind of to be understood in the sense that each branch of government can check the power of the other branches. Now, one of the things that we understand about the judicial branch is that its officers are appointed by the president or the executive branch, but then confirmed by the Senate in the legislative branch, right? So that is a check across the board. So it's just something that I kind of want to make sure that you're aware of. There's also, we need to understand exclusive versus concurrent jurisdiction. Exclusive meaning just applicable to that, what do I want to say, that level, or that yeah, level of government. So in this case, if we talk about exclusive jurisdiction, federal jurisdiction, we tend to see cases involving federal crimes or antitrust law or bankruptcy, patents, copyrights. You can read all that, or suits against the United States. So those are federally exclusive. We also have exclusive state jurisdiction. Those are cases involving all matters not subject to federal jurisdiction. So if it's not included here, then it automatically becomes a state matter. And of course, there are times when they share, concurrent means to share jurisdiction, cases involving federal questions, diversity of citizenship, things like that. That's not that important at the moment. So hopefully that helps. That's just a brief introduction.